When police get a domestic violence call in Florida, it kicks off a very strict and honestly a widely misunderstood legal process. The rules are automatic, the big decisions are taken right out of the hands of the people involved, and the consequences? They are immediate. So today, we're going to map out exactly what happens, step by step, right from the moment of that arrest.
Look, it's an incredibly stressful situation for everyone. So what actually happens from here? We're going to walk through the entire system chronologically. We'll start with that initial police encounter and go all the way to the different paths the case can take so you can really understand the exact sequence of events just as Florida law defines it.
It all starts right there on the scene. When law enforcement shows up, they're not just there to break things up. Nope. They are bound by two key state policies that tell them exactly what to do: a mandatory arrest rule and a required risk assessment.
The most important word to understand here is required. This isn't up to the officer's judgment call. Florida has what's called a mandatory arrest policy. So, if the officers have probable cause, things like visible injuries, a credible witness, maybe a 911 recording, they are legally obligated to arrest the person they believe is the primary aggressor.
But it's not just about the arrest. There's another required step. Officers have to administer something called a lethality assessment. Now, this is an evidence-based screening tool. Basically, a specific set of questions designed to figure out the immediate danger a victim might be in. Its whole purpose is to flag those high-risk situations right then and there. And this isn't just some local thing. The Florida Department of Law Enforcement, the FDLE, is the one that developed this standardized statewide protocol. This makes sure that every single officer all across Florida is using the exact same method to assess risk, which creates a really consistent standard for every single case. And let me tell you, the questions are incredibly direct. They're sobering. The officer is going to ask things like, has he ever threatened to kill you? Has he ever choked you? Does he have a gun? And the answers to these questions actually trigger specific next steps, like an immediate call to a domestic violence center if a certain risk level is reached.
Okay, so this leads directly into the next phase. After the arrest, those first 24 hours are absolutely critical. The person who is arrested is taken into custody, and a bunch of automatic legal barriers are immediately put in place even before they're released.
So here's how it goes down. After the arrest, the accused is held without bond. They can't just pay bail and get out. They have to wait for their first appearance in front of a judge, which legally has to happen within 24 hours. And at that hearing, the judge almost always issues an automatic no-contact order.
So what is a no-contact order, really? Well, it's a legally binding command from a judge. It's not a suggestion. It forbids the defendant from having any kind of contact whatsoever with the victim while the case is going on. And the key words to remember here are direct or indirect. And this really shows you just how serious it is. No contact literally means no phone calls, no texts, not even a message on social media. It means you have to stay 500 feet away from their house or their job. And this is crucial. It also means you can't just ask a friend or a family member to pass along a message for you. Any violation of this is a brand new criminal charge.
And here is probably the most important point. The victim has zero control over this order. Even if they change their mind, even if they're the one who reaches out to the accused person first, it doesn't matter. The order is from the court, and only the judge can change it or lift it. The victim cannot give anyone permission to violate it, period.
This brings us to the single biggest misunderstanding in these cases. Once an arrest is made and the court gets involved, who is actually in the driver's seat? Who's the one that decides if the case goes forward?
This is the question everybody asks. It seems logical, right? If the person who made the complaint decides they don't want to go through with it, the case should just go away. But in Florida, well, that's not how it works at all. The answer is a clear, simple no. Once the state gets involved, the alleged victim just doesn't have the power to drop the charges. That decision is in someone else's hands entirely.
So here's why. The legal case isn't between the two people, it's the state of Florida versus the defendant. The state attorney's office takes over, and they follow a no-drop policy. Now, this policy is designed to protect victims who might feel pressured or intimidated to take back their story, a problem that made these cases really hard to prosecute in the past. Prosecutors are really good at building cases without the victim's help, using evidence like the 911 call, photos, and police body cam footage. In fact, the whole system is kind of built for this, because some estimates say that up to 80% of victims end up not cooperating.
So if the case is moving forward no matter what the victim wants, what happens next for the accused person? Well, generally speaking, the case is going to head down one of two main paths. The first path is usually a pretrial diversion, or what's called a first offender program. This is more of a rehabilitative route for people without a prior record. It focuses on counseling, and the goal is to get the charges dismissed. The second path is to actually fight the charges in court. Challenge the prosecutor's evidence and build a defense.
Let's take a closer look at that first offender program. First, an attorney has to check if the person is even eligible. Then, they negotiate with the prosecutor to get them into the program. After that, the defendant has to complete all the requirements, which often means a long-term batterer's intervention program. Only after they've done everything successfully does the state finally dismiss the charge.
Now, you might hear people talk about marital privilege. The idea that a spouse can't be forced to testify against the other. And yeah, that privilege does exist in Florida, but there is a massive exception. It does not apply in a criminal case where one spouse is charged with a crime against the other. So, in a domestic violence case, it offers absolutely no protection.
To wrap things up, let's clear up one final, really common point of confusion. There are actually two different kinds of protective orders in Florida, and they come from two completely different legal processes.
All right, so on one side, you've got the criminal no-contact order that we've been talking about, which is automatic after an arrest and is part of the criminal case. But then on the other side, you have a domestic violence injunction. Think of this as a civil restraining order. A victim can file for one of these in civil court anytime, and it's totally separate from any criminal case. And get this, the two can even be in place at the exact same time.
So, from mandatory arrests and these lethality assessments to no-drop policies and automatic court orders, the Florida system is a really rigid structure. It's a system built on decades of experience, and it's designed to take the decision-making away from the people directly involved. And that leaves us with the final, really important question. By creating all these automatic, inflexible rules, who is this system ultimately designed to protect? The victim, the state, or the public as a whole?